Welcome back. So, here we are talking about landlord-tenant cases, and I'm going to act like you know nothing. So, there's two types of eviction cases: recovery of possession and non-payment of rent. In this video, we're going to talk about recovery of possession case. If you're interested in learning more about a non-payment of rent case, there's another video for that. But in this case, we're only going to talk about recovery of possession. Now, what does that actually mean? If I'm a landlord and I want my property back, I want to recover possession, full rights, to my property from the person I lend it to, borrow, or renting it from me. A recovery of possession case is usually in situations where, 1, the tenant owes rent and haven't paid. 2, the tenant has violated a term or condition in your lease agreement, such as having the police come and break the door down, domestic violence, they damaging your property, they got a dog and you said you don't want no dogs, stuff like that. Or a month to month. Your lease has expired and now you live every 30 days in the space and you pay rent, and the funds that are paid at the top of the month only last you to the end of the month. And then you must pay again, otherwise I would like my property back. A lot of people run away from the idea, a lot of people meaning landlords, tend to run away from the idea of doing a recovery of possession case because it starts with a notice of quit. But that notice of quit has an expiration date of 30 days. And so people say, oh, well, I want my property back faster, so I don't want to do a 30-day. I suggest you consider this as an option. So, a recovery of possession case starts, as I mentioned, with a notice to quit. And that notice to quit at the top says recovery of possession. And you would mail it to the tenant, and they would have 30 days to pack up their things and go. You don't want any money. I know, it hurts. I know it hurts. But listen, it may be worth the time, effort, and energy. So follow me, just follow me, okay? So you have 30 days from the day that you mail the notice to quit to the tenant. The tenant does not move out after day 30. By day 33, because again, the U.S. Postal Service has rights. They have 3 days, an extra 3 days to send you your things to where it belongs. In case they have shortages, life happening, holidays, you know, they don't care about your property. So, got to wait 33 days before you are able to file your summons and complaint. So that is the documents that we would file with the court to start the actual eviction case. So on day 33, day 34, we go to the courthouse and we file the paperwork. When we're filing the summons and complaint, they still want to know, are you the owner? A property manager can file and mail or send, sign, prepare, and mail the notice to quit to the tenant or the occupant or the squatter in some instances. But the property manager cannot be listed as the plaintiff for the lawsuit. And the reason they can't is because name is property manager. They manage the property, they don't own it. The owner of the property, who's listed on the deed of the property, who we're going to attach to our summons and complaint when we file it with the court to let the judge know I own it and they need to get out. You follow me? Is who needs to be the plaintiff listed on the eviction document. Now, when we get to court, you still have 2 court hearings, but typically only in Detroit. Metro Detroit is with 1 court hearing. You have that 1 court hearing and we're all set. Detroit says, nah, we gotta help the people here. So we're gonna have 2 court hearings. First one's gonna be by Zoom, which gives us a day where the tenant can come to court Tenant is then given the opportunity to get a court-appointed attorney, and as the landlord, you get to sit on Zoom, get the new court date, and come back in person the next time. When we get to the in-person court hearing, that's the day you're requesting a move out. Thank you. It's been real. It worked until it didn't. Now, the law in the state of Michigan says a tenant has 10 days. You see that? All the fingers. 10 days to move out. But there's a subsection to the law that says unless the judge sees otherwise or with judge's discretion. Well, the average judge's discretion is 30 days. Okay, so your negotiation window is between 10 days and 30 days. Unless it's super real bad circumstances and situations, a judge can push that beyond 30 days, but on average it's about 30 days. So you have to put yourself in the mindset that says, okay, I know by the time I get to my second court date, it's likely that the move out is going to be 30 days. If the tenant, occupant, or squatter fails to appear in court, you're going to get your 10 days because that's a default. Default means 10 days. If they do show up, it is likely going to be somewhere between 10 and 30, or if the judge says that these are just extreme circumstances, it may be beyond 30 days. But there's no need for repairs to the property. Unlike the recovery of possession, unlike the non-payment of rent case. There's no need for a new court date because it doesn't matter if they get rental assistance. You're not asking for money. You're just asking for your property back. Now, one disclaimer, because people don't always understand this. With a recovery of possession case, the moment you send that notice to quit out to the tenant, you have to stop collecting money from that tenant. So if you decide, I'm going to start this recovery possession case, and you know what, I'm going to look out for them, I'm going to help them, and they give you a couple of dollars, I warn you, this is a bad idea. You're going to have sympathy because that's what we do as landlords. And they're going to bring that up in court against you. Oh, well, he took my money, so you know, she took the money. Case dismissed, and you will start all over because you took $1 from that tenant, occupant, or squatter. So I give you fair warning. You may burn and feel the burn that you want the money. I know. But you have to decide if you want the property or the money because they are going to stall you out again in the future. The odds are they are going to do this again. They've probably already done it. And this is why you're at the point of considering filing eviction. Just file it. Get that order. If you guys make arrangements after that, then that's on you guys. If you make arrangements after court. But do not do that while everything is still in play because the procedures are no money, just move. If you receive money, start over. Game over, start over. And that includes your 30-day notice to quit. You cannot say, well, I already sent the notice to quit, and even though I took a couple of dollars from them, I want to keep moving forward. Because they're going to come to court and tell the judge. And the case is going to be dismissed, and you got to start all over. But if you follow all the rules, you will get your property back. Smoother sailing. Doesn't matter if building and safety is there. There's not really too much questions about if there's a certificate of occupancy, although you should do that because it's the law. But all of those things will not take into effect that will stop you from being able to get your property back and getting that occupant out of the property. If you have any additional questions or concerns, give us a call. We'll be able to help you answer some of those questions and get you on the right track to getting your property back.